use of any other language for official purposes. Okay? Nevertheless, the majority opinion in the Descartes case converges with the position adopted by some authors and presented as best practice by some international bodies, like the High Commissioner I spoke about before. And if such an opinion should someday in the future attract a consensus, it would no longer be legitimate for a state to limit its communications with citizens only to the language or languages it has declared as official. And in such a case, the provision of Bill 101 making French the only official language of Quebec would be, of course, vulnerable to a challenge based on this new principle. And the same would be true, of course, of the provision of the Canadian Constitution declaring French and English to be the only official languages of Canada. Now I will, perhaps it will answer to the question you have put before. I will try to introduce the concept of reasonable accommodation. I will try to introduce the concept of linguistic accommodation, or reasonable accommodation extended to the linguistic field, if you like, as possible foundation for certain linguistic obligations of the state as regards the official use of languages. One, perhaps the most important deficiency, drawback of the reasoning adopted by the majority in the Descartes case and of the similar position presented by some authors, the main drawback, the main deficiency is that the obligation of the state to use minority languages with regard to the official purposes is analyzed as being founded only on the prohibition against discrimination. It is analyzed as arising completely, entirely, and only from the right to equality. And the problem with such a point of view is that, thus, it does not offer any useful guidelines as to which field in particular and for which aspects of its activities the state should function in languages other than its declared official languages. In consequence, the reasoning implies that such an obligation would apply in a general way for all the activities of the state, ranging from the most important to the most mundane. However, such a conclusion seems unreasonable if one thinks of the costs and complications involved in requiring the state to function in a great number of languages. A solution to this difficulty could be to consider that the state had the obligation to use languages other than its official languages only when the refusal to do so would cause not only a form of discrimination, which is always the case, but also would cause a restriction of another right or freedom considered as fundamental. And the classic example of such a situation is precisely that of a person charged or tried for a criminal offense and who does not understand the language of the procedure or who is deaf. Such a person is then entitled to the assistance of an interpreter and or to translation services. Usually, the right to an interpreter is recognized expressly in national laws and constitution, as well as in international treaties on human rights. But when it is not expressly recognized, as is the case, for example, in the United States Constitution, it will be considered as deriving from the basic right to a fair trial. So, the right to an interpreter, when it is considered as deriving from the right to a fair trial, seems to be based on the following principle. Insofar as the ignorance of the official language prevents a person from enjoying a freedom or a right considered fundamental, like the right to a fair trial, for example, the state has the obligation to make a linguistic accommodation intended to help the person to overcome his or her handicap and consisting, in this case, in the provision of an interpreter. Now, the same reasoning that I just made for the right to interpreter can obviously be applied to state functions other than the judicial functions, as, for example, the operation of the electoral system, by providing electoral materials and ballots in various languages, the provision of public health care by providing interpreters in public hospitals, or the provisions of public education. And as regards this last instance, the Supreme Court of the United States, in the celebrated Law versus Nichols case, ruled that the right to a meaningful education without discrimination based on national origin required that children of Chinese ancestry who do not sufficiently understand the English language in which public education is dispensed in San Francisco public schools be provided with adequate instructional assistance. And such assistance can take the form of English language proficiency courses or the form of bilingual education, bilingual English and the mother tongue of the children for a certain period of time. And to come to this conclusion, the court referred, among others, to the following guidelines published by the Department of Health, Education and Welfare of the United States, quote, where inability to speak and understand the English language excludes national origin minority group children from effective participation in the educational program offered by a school district, the district must take affirmative steps to rectify the language deficiency in order to open its instructional program to these students. And this guideline seems to me as expressing the concept of reasonable accommodation in the linguistic field. It's a very clear expression of the concept of reasonable accommodation in linguistic matters. Thus, it is possible, it could be possible to argue that there exists a right to linguistic accommodation as regards the official use of languages whenever the fact that the state functions only in its official language causes the infringement of a right that can be considered as fundamental in addition to causing discrimination. You see? In addition to... And I think the importance of adding the requirement of an infringement of another right, the right of equality itself, is that it permits to delimit and to restrict more precisely the areas in which a multilingual functioning of state would be required. And when you base such a reasoning only on the principle of equality, you have no such guidelines, because the principle of equality applies across the board. Once you consider that it's a discrimination for a state to function only in Spanish, in Castellano and Catalan, and that it should also function in language other than these two, then you cannot determine very easily which function should be applied. But if you use the requirement of the infringement of another right, like the right to health services, or the right to education, or the right to a fair trial, you may be able to delimit more precisely and to restrict to the most important needs the right of minorities to have the language used in the official functions of the state. So I think it's an improvement, in a sort of improvement on the reasoning which is defended, for example, by Professor de Varenne, and which I presented before. Now, as with any other right, the right to linguistic accommodation is not absolute. It can be limited in a reasonable way. Thus, such a right exists only insofar the costs for the public authorities or the constraints on public interests it involves are not excessive. It must also be noted that the right to linguistic accommodation ceases to exist as soon as the accommodation is no longer necessary, because the obstacle to the full enjoyment of the right of freedom has disappeared. And thus, to take again the example of the situation in Law versus Nichols, once the Chinese ancestry children have become able to follow English schooling in a normal way, the need for the accommodation has disappeared, does not exist anymore. So, to conclude this first part of my presentation, the linguistic policy of Quebec seems to be, for the time being, in general conformity with the linguistic liberty implicitly deriving from general human rights guaranteed in international law. However, it must be noted that the trend in this field is in the direction of an increase in the recognized guarantees, and if certain tendencies that I have examined right now were confirmed, some elements of the Quebec legislation or any similar legislation could be considered as not being entirely compatible with the emerging international standards. So let me now turn to the second part of my presentation, if I have still time. It will be shorter, and it's much more technical because it's about the constraint deriving for Quebec's and Canada's linguistic policy from international trade agreements and from the agreements pertaining to the economic integration in North America. Now, it is well known that international trade agreements expose national linguistic policies to attacks, insofar as these national linguistic policies could be regarded as imposing obstacles to the exchange of goods and services. The fundamental rule of trade agreements is that of national treatment, which prohibits any difference of treatment between national and foreigners. Now, it is true that the provision of a linguistic policy, which require the use of the knowledge of the predominance of a particular language, apply as well to nationals as to foreigners. But one could easily argue that they involve indirect discrimination against foreigners who do not know the prescribed language, insofar as they are more constraining with respect to them. The measures forming part of national linguistic policies that are the most likely to have negative consequences on the free trade of goods and services, and thus are the most likely to be attacked on the basis of the rules of international trade, are measures relating to labeling of consumer products and advertising, measures imposing linguistic requirements for the exercise of certain professions, measures limiting for linguistic purposes the importation of cultural goods or services, measures conditioning the granting of subsidies on the basis of linguistic requirements, and measures granting preferences at the commercial level to certain foreign countries on the basis of linguistic consideration. Trade agreements usually include general exceptions relating to the protection of public health or to consumer protection, exceptions which are likely to justify some linguistic requirements, for example, as regards the labeling of consumer products or the exercise of certain professions, but on the condition that such requirements remain reasonable and proportionate to the pursued objectives. However, a linguistic policy like that of Quebec pursues goals well beyond the simple protection of public health or consumer production. It is aimed at the protection and the promotion of the French language for political, social, as well as symbolic reasons. And it is far from being sure that such objective would be regarded as acceptable justification for the restriction of trade. Canada has been a member of the World Trade Organization since its inception in 1995. At the regional level, Canada is a member with the United States and Mexico of the North American Free Trade Agreement, NAFTA, which followed the free trade agreement previously concluded between the United States and Canada. In fact, the conclusion of the NAFTA treaty had as its main objective to extend the application of the free trade agreement to Mexico, while applying its provision to certain new areas, for example, transportation. I will first examine the potential negative impact of NAFTA on Quebec's linguistic policy. I will then briefly mention the rules on the use of languages in the settlement of disputes within NAFTA, and I will conclude by reviewing some proposals made in order to protect Quebec's linguistic policy and more generally the position of the French language against the potentially negative effect of economic globalization and the continental economic integration of North America and of the Americas. But before continuing, I must make a confession. I must confess that I'm far from being a specialist in international trade law or the law NAFTA. And my presentation on this subject is largely borrowed from articles written by other people and in particular Professor Yvan Bernier from the Laval University in Quebec City. I shall also add that contrary to what had happened in Europe, where European Union law has had some notable effects on the linguistic policies of certain member states, France for example, to my knowledge, no provision or element of Quebec's linguistic policy, of the linguistic policy applied by the federal government of Canada, has yet been challenged under the rules of NAFTA or under the rules of the World Trade Organization. In consequence, the examination that follows is entirely theoretical and hypothetical. Okay? So, as to the potential impact of NAFTA on linguistic measures, one must distinguish the provisions relating to the trade of goods, those relating to the trade in services, and finally the provisions and measures relating to cultural industries. First, the provisions relating to the trade of goods. Insofar as they could be regarded as harming the trade of goods, linguistic measures would be subject to the requirements of Article 301, national treatment, and 309, prohibition of quantitative restriction of NAFTA, which in fact integrate the provision of Article 3 and 11 of the GATT of 1994. And Professor Bernier notes that the rules of national treatment could be called upon under both the terms of GATT and of NAFTA to challenge, for example, the quotas on film screening established on the basis of language, as well as the subsidies granting according to criteria including language in order to support the production and the distribution of the film industry. As for the prohibition of quantitative restrictions, it could be used to challenge, for example, measures relating to the labeling of consumer products. And Quebec, as well as Canada, have adopted regulations requiring the labeling of consumer products in one or both languages, one or both of the official languages. Canada imposing the use of two official languages, French and English, Quebec requiring only the presence of French. Now, within the framework of NAFTA, the national linguistic measures likely to be attacked as having a restrictive effect on the trade of goods would qualify under the general exceptions envisaged by Article 2101 of NAFTA, which incorporates into NAFTA the general exceptions of Article 20 of the GATT. And this latter provision authorizes the adoption of measures necessary to protect human, animal, or plant life or health, as well as the measures necessary to secure compliance with law or regulations which are not inconsistent with the provision of the agreement. Linguistic measures having a negative effect on cross-border trade in services, now, my second point, would be subject to Article 1202, national treatment, and 1203, treatment of the most favored nation. They would benefit from the reservation registered by each party under the terms of Article 1206. However, Canada did not adopt any reservations intended to include linguistic measures having a negative effect on the trade in services, but with regard to professional services, insofar as Annex 1210.5, it's very technical, excuse me for that, insofar as this annex of NAFTA engages the parties to work together in the future in the development of mutually acceptable standards, it is considered as recognizing, at least implicitly, that the linguistic requirements relating to professional qualification or recognition are not incompatible with NAFTA. Finally, provision relating to cultural industries, very simple. Article 2106 of NAFTA refers to Article 2005 of the Free Trade Agreement between Canada and the United States. Article 2005.1 exempts cultural industries from the rules of free trade. And these industries are defined as including books, periodicals, newspapers, film and video recordings, audio and video musical recordings, broadcasting, television, and cable distribution. Any measures concerning this industry, including linguistic measures, are thus completely protected. My second point now, the rules governing the use of languages in the dispute settlement provisions of the NAFTA. The only provision of the NAFTA main agreement relating to languages is Article 2206, which provides, quote, the English, French, and Spanish texts of this agreement are equally authentic. So there are no more provisions in the NAFTA main agreement about languages, but more detailed provisions on the use of the languages are to be found in the rules and procedures of the bodies and organisms competent for litigation arising in the application of NAFTA. And these provisions are very detailed and technical, and anyone interested in them will find the complete wording in my written paper. In my whole presentation, I will only take one example to give you the flavor of these rules and procedure, the example of the rules and procedure for Article 1904 of NAFTA by national panel reviews. Rules 29 to 31 apply with respect to panel reviews of final determinations made in Canada. Under Rule 29, either English or French may be used by any person or panelist in any document or oral proceeding. And Rule 30 lists the many instances in which any order or decision, including the reason thereof, issued by a panel shall be made available simultaneously in both English and French. And I spare you the other rule of procedures, but similar rules apply to the other dispute settlement procedures. So, on a theoretical plane, the French language is put on an equal footing with English. However, I have interviewed a colleague from McGill University in Montreal, Professor Armand de Métral, who has been a member of binational panels and other bodies involved in the dispute settlement procedures of NAFTA. And he told me that the actual functioning of this procedure, and not surprisingly, the English language is a common denominator between the members of the concerned bodies, with the consequence you can imagine. And finally, and it will be the end of my expose, and excuse me if I've taken too much time, I will take a quick look at some suggestions that have been made to protect the linguistic policy of Quebec and more generally the position of French in North America against the potentially negative effect of economic globalization and of the continental economic integration of North America. Globalization and the continental economic integration of North America, as we have seen, raise threats and dangers, at least potentially, for Quebec's linguistic policy. But what is more important, in a much more general sense, the same phenomena also present worrying aspects for the position of the French language in North America and in the Americas more generally, insofar as the future will probably see continental economic integration spreading to the whole of the American continent, as evidenced by discussions taking place already to create a free trade zone of the Americas, FTAA. Now, you must know some facts in order to appreciate the dangers and threats to the position of the French language in North America and in the whole of the American continent. In North America, French speakers represent 3% of the total population, Spanish speakers between 25 and 30%, and English speakers over 60%. In the whole of the American continent, French speakers amount to less than 1%. There are more speakers of Quechua than French speakers on the American continent. Spanish and Portuguese being, to a good degree, mutually understandable, at least in writing, it has been remarked that it could well be that rather to invest time and money in learning another Ibero-Romance language, Latin Americans decide to concentrate on English. And already the teaching of French has undergone a notable decline throughout Latin America. In consequence, on a linguistic level, the economic integration of the American continent will probably be to the advantage of both the English, of course, language, but also the Spanish language, and to the detriment, to the disadvantage of the French language. Now, the Conseil de la langue française of Quebec, the Council of the French Language of Quebec, an advisory body to the Quebec government in linguistic policy matters, in an opinion released in 2001, has made a number of recommendations to the government of Quebec to try to develop multilingualism and thus to counter the hegemony of English within the framework of the economic integration of the Americas. Let me, to finish, quote some of these recommendations. First recommendation, that the government of Quebec requests that the Canadian federal government have included in the plan of action of the Summit of the Americas the need to officialize and strengthen institutional and commercial multilingualism and to support the development of individual plurilingualism. Recommendation number 4, that the government of Quebec, together with the federal government, urge the inter-American organizations to consolidate their multilingual nature by ensuring 1. All official documents and general interest documents are translated into each of the official languages. 2. The information of the internet sites is made available in each of the official institutional languages. 3. All the official languages are treated on an equal footing in the hiring of personnel. 4. Plurilingualism is fostered among the staff by providing language courses or traineeships. 5. It be made possible for any citizen to communicate with an inter-American organization in one of the official languages of that organization and receive an answer in the same language. And finally, 2 other recommendations, and that will be my conclusion. Recommendation 8, that the government of Quebec support the creation of an inter-American network for the promotion of languages in the integrated Americas to be devoted to enhancing the value and respect placed on language diversity within the process of integration of the Americas, and that the government of Quebec, in collaboration with its partners in the Americas, establish an Inter-American Bureau of Languages with a mandate to monitor language development in the context of integration and to propose measures favoring the respect, learning and dissemination of languages within the Americas. Thank you for your attention.
Thank you very much. We have 10 minutes for discussion if you want to make some question.
Continuing with the reasonable accommodation idea, what is the final consequence of implementing it into a public education system like ours or yours? Is it going case by case, or is it going towards a free choice?
No, it would be going case by case. The concept of accommodation, by definition, is applied on a case-by-case basis. Be it in the field of linguistic matters or in the field of religious matters, because as you probably know, the concept of reasonable accommodation in Canada as well as the United States has appeared as to religion. For example, if a school prohibits pupils to come to school by wearing arms, it has been ruled by the Canadian Supreme Court that an accommodation has to be made in order to allow Sikh students not to respect this prescription and to be able to come to school with their ceremonial dagger that is called a kirpan. So, no, accommodation, reasonable accommodation, religious matter, linguistic matter is by definition applied on a case-by-case basis. So, each time a person has to come before an authority or a tribunal and to show that a requirement that is neutral facially, that is applied equally to everyone, a policy that is neutral, the state speaks only in French or in English, but it has the same policy towards anyone, a general rule or policy neutrally applied has adverse effects on a group or person because of a prohibited ground of discrimination like language or religion or the prohibition of discrimination because of disabilities. Okay, and then it must be examined if it is possible to make an accommodation to allow the person to fully enjoy the rights and freedoms that are guaranteed without compromising public interest. If the accommodation is too onerous, costs too much, compromises another public interest, it will be refused. There will be no right to accommodation, no duty from the part of the public institution to accommodate. But if it can be shown that the accommodation can be made, can be accepted without compromising public interest or without compromising public finances, then it has to be accepted. Okay? And what would be the importance in linguistic model? It would be not that much important. It would simply mean that even if a state has declared one language to be its only official language, and if in a general way the state can limit itself in its communications with the citizen to that language because it's the only official one, there will be certain exception cases in which, on the basis of the concept of reasonable accommodation, the state will have to make an exception and will have to accept to function, to have its organisms, its public function be done in languages other than its official language. When, in what cases exactly? When it can be shown that the refusal to do so causes the infringement of a right that can be considered as very important, as very fundamental, like right to a public trial, to a fair trial, to a public and fair trial, right to an effective education, to a meaningful education, like in the Law versus Nicol case, right to decent health care. When I go to a hospital and I'm unable to understand or to speak the language of the hospital, it's impossible for me to get acceptable health care, you see. And so the state has to accept to function in languages other than its official languages, because to do otherwise would be to deny to those persons the right to minimal health care, to decent health care.
Other questions or you don't have?
I don't know if I have understood correctly all your explanations, but I have felt a little lack of consideration of the linguistic minorities, for instance, in the case of Namibia. Since, if you consider only the officiality of the language of the state and the individual rights in general terms like health and so on, I feel that, well, I don't know if the committees, the international committees have in account the fact that in these values, in these balances, should be considered the fact that there are banned the original languages of Africa have been absolutely banned, and then I don't know if there is some kind of possibility to have into account the fact that in that situations there are languages that are banned, and so they should be considered to raise rights in favor of the use of those languages.
Okay, yes, perhaps the committee took account, but it didn't say so, you see. And I think that from a purely factual point of view, the decision of the majority in the Dirkart case is probably a good decision, because I think on the factual level it was not reasonable on the part of the Namibian government to refuse to correspond with citizens in the African language, since it has been the traditional language in that country. Okay. But in its reasoning, in its justification, in its argument, the committee did not say so. If it had said so, then it would be different. What bothers me is that the Diergaardt case may be considered a good authority for the following proposition, that as soon as the state refuses to communicate with citizens in languages other than its official languages, it commits discrimination. Huh? And I'm at war with the majority opinion of the Diergaardt case. I'm at war with that opinion, not because of the result. I think the result was quite good on the factual level, because it recognized some rights to the African-speaking people of Namibia, but because of the justification, of the legal justification, and of the legal conclusion you can derive from that opinion. And if someone tries to derive the conclusion that there is discrimination as soon as a state refuses to communicate with citizens in any language other than its official languages, that it doesn't make sense. It would mean that the Catalan state commits daily discrimination because it doesn't communicate in languages other than Catalan or Castellano. It doesn't communicate in Chinese, although I'm sure there are many Chinese-speaking people in Barcelona. Does that mean that the Catalan state has to communicate with these people in Chinese and in the Albanian and in any other language spoken on the face of earth as soon as one person speaking that language comes to reside in Barcelona? No, of course. So you cannot accept the majority opinion in the Diergaardt case on the level of the legal justification. It doesn't make any sense. On the level of the factual operation, the factual result, it's perhaps excellent, but it should have been justified in another way. Committee should have said, in a general way, the state does not have an obligation to communicate with a citizen in languages other than its official languages, which is exactly what the dissident members said. But there are certain cases where one must make an exception to this general rule. And my concept, the concept I'm trying to defend of reasonable accommodation, is precisely I mean to make some exceptions, but limited exceptions, you see, to the general rule. And in Catalonia, you have every interest to accept such a point of view, because your interest is to be able to defend the Catalan language, to use only the Catalan language for official purposes, but at the same time of being prepared to make certain exceptions when it is really necessary. Of course, if someone comes to a hospital in Barcelona, bleeding, losing all his blood, and does not speak Catalan, you're not going to say, no, we won't treat you because the only official language of Catalonia is Catalan, or because it's... And then you will have to accept to communicate with him in a language other than Catalan. But you won't have to do the same all the time for any function of the Catalan state. If you had the second obligation, then the official linguistic policy of the Catalan state would be in tatters, would be in ruin, you see. So precisely, I think what I'm trying to do is first accept the legitimacy of the general rule that a state can refuse to function in language other than its declared official languages, because such a rule precisely allows societies like Catalonia or Quebec to defend their majority language, but which at the same time is a minority language on the national level. And then, after having established the legitimacy of the general rule that a state does not have to use for official purposes languages other than its official languages, I go on and I try to find a legal basis for allowing some exceptions, but some limited exceptions, some exceptions that are really necessary. And I think that the concept of reasonable accommodation, those are part of the way of doing this, you see.
Well, we go to do the break. Thank you very much.